Newsfirst Newsline with Faraz Shaukat Ali.
And top of the morning to you. This is Newsline, live from the Newsfirst studios in Dawson Street in Colombo. And joining me this morning is double trouble, I think. Krishmal Varnasuria, the Joint Secretary of the People's Intellectual Assembly, PIA. Wonderful set of abbreviations.
Thought it was appropriate.
Yes.
During the times.
Oh, right. Pain. Right. And also joining us is, I'm going to do it differently this morning, Mr. Producer. The guest is going to tell us who he is.
Asoko Obesekar of Transparency International.
Wonderful. And he's here to talk about the right to information. Are you happy now that it's been passed into law?
Indeed. I think it took a little bit of time for the Speaker's certificate to come along, and we are a little concerned for a short while there. Mm-hmm. But we're glad of it.
Because the Speaker was ill, or was there
I mean, I don't... Obviously, there's a Deputy Speaker for those particular instances.
Of course, yeah.
I think part of the reason was that there was one amendment made at the committee stage which hadn't been pre-planned.
Right.
So they were sort of tinkering with the wording there. But anyway, it's now been sort of it's certified and it is now law.
Right.
I think the one the Transparency International's position on it is that the initial draft RTI bill that was there didn't cross the threshold of support.
Right.
But after the tinkering and the improvements within that bill, whilst it's still not perfect, it certainly is a step in the right direction.
Good. And what does that mean to people in the media if we are searching for information? What does that mean?
So I think what it means is that now the default position, which may have at one point been to just say no, that information, we will deny that information.
Yeah.
It is now a case that the state, it really recognizes the fact that the state holds the information on behalf of citizens, and on particular areas information may be not given.
Right.
But the default position is that information will be given. However, just to mention one thing connected to your question there, this act is not going to be successful if it is seen as a purely media-focused act. It needs to be seen as sort of a citizen-focused act that the media can also use.
I see. So once more we've been almost sidelined.
I wouldn't say that. I wouldn't say that. All I would say is that the responsibility isn't solely yours. Citizens need to be proactive with it.
Right. And Krishmal, what's your take? What are the? Can you tell us what the exclusions are? Because that usually gives the game away.
Yeah. If we come to the exclusions, can I just say, I agree with Asoka. It's good. Primarily, what we've got is good. Not ideal, I agree with you. We've got a long way to go. But as a concept, the recognition that the citizens have a freedom to access information, and that should be unimpeded, at least in principle, is good. So something that, you know, when we see something that we fought for on the roads out there, risking a lot for us, when we see it coming to life, we must appreciate that. So, but now, this is where I ask the citizens to be cautious. You shouldn't give something or show that you're giving something and take much more away. This is where you come to your exception. Now, long before we came to this Right to Information Act for us, which came across the House yesterday, remember that the 19th Amendment we drafted, which I also had little part to play as well at the drafting stage and in the Supreme Court in the determination.
And then it was sort of mysteriously...
No, hang on. In the 19th Amendment, we already have the right guaranteed as a fundamental right in this country.
Right.
You see, in the 19th Amendment last year, which we came close upon the Yahapala regime being established, we had a right to information in the Constitution. And that's a supreme law. As Kelson says, the Grundnorm, the absolute law. All these other laws are ancillary to the Constitution. All the other laws are based upon the power given by the Constitution. Now, in the Constitution, we, whilst giving the right, 14 Navy amended, whilst giving the right to the citizens for us, we had, I think, the acceptable exceptions, which are no restriction shall be placed, it says. No restriction shall be placed except under the law, and then it says territorial integrity, national security, public safety, prevention of disorder of crime, protection of health morals, and privacy, prevention of contempt of court, protection of parliamentary privilege. Now, that has given, in my opinion, sufficient exemptions to the right. What this law, in my opinion, now seeks to do is to actually take away much more than it gives. Because we gave the right as a fundamental right in the Constitution last year. This law, in my view, is another carrot. Is another carrot being thrown to show that, well, you all have a right, but and we'll go to the exception one by one later. We are, in my opinion, they are trying to take away much more than what we gave last year in the right as a fundamental right.
When it says one of the exceptions is privacy, what, in practical terms, what can you say?
Precisely, not just that. If you look at all those, if you look at all the exceptions, for example, say privacy, who's going to decide that? Now, if you look at also precisely the interpretation that now lots of things they say. I'll come to the clauses. Do you have the clauses where the exceptions are now? Can I just?
Yeah.
So the iPad takes a bit longer. Subject to the provision. Information relates to personal information or disclosure for us. Then would accommodate the now defense. We had to let go. That I think is across the board. Would be likely to seriously prejudicial to Sri Lanka's relations with any state. Now, who is deciding this? Then again, the disclosures would cause serious prejudice to economy. In whose opinion?
So
you are the returning, what do you call the officer? The information officer. You think no, this information is prejudicial to Sri Lanka's economy. And the rate that our public officers, with all due respect to them, our public officers now thinking like government servants.
I just want to put this into perspective. Suppose I wanted the details of the last central bank bond details. Could they turn around and say, well, it might be prejudicial
to Sri Lanka's economic interests?
Well, in fact, I'm trying to expose what would actually be prejudicial to our economy. So, what happens in these cases, Sanka? Can you?
I mean, on the economic issues. I mean, it's broken down into 5 areas. So information is excluded if it impacts exchange rates or the control of exchange transactions, the regulation of banking or credit, taxation, the stability, control and adjustment of price of goods and services, the entering into of overseas trade agreements. So
that's the entering into of overseas trade agreements is going to be an exclusion.
Yes,
but it's a significant part of our interest.
Yeah. So I think so I think there's a couple of points here. The first thing is that all of these exemptions are subject, and I can appreciate that there would still always be concerns on this, to a public interest override. So I mean, if the public interest is deemed to be greater than the weight of the interests, the information that is being withheld, it should be disclosed. The issue is that how that will happen.
Who decides?
And so now, even with information officers, I mean, this will be very difficult in practice. I mean, when things start out, given the fact that our public service currently operates under the establishment code, where everyone has been having a very sort of closed mind on sharing information. Now we have a Right to Information Act, which is supposed to be about giving out information. So to start with, there will be many issues like this. And so information officers they have to respond within 14 days of having a request to whether they will give the information or not. And then within another 14 days, they must provide that information. So in a typical cycle will be 28 days maximum from asking the information to receiving the information,
or to receiving a no.
Yes, but the issue is that the elephant in the room here is really in the implementation. How the state goes about rolling out this entire RTI infrastructure is going to be very, very challenging, and the ministry in charge of RTI is the media ministry. So it's going to be a very tall order to ensure that within 6 months the act is operational, and then within 1 year, it's not in the bill, but the final gazetted act, which is still not in hand, will, I think, say something to the effect of within 1 year the entire act must be operational, and to some extent it must start off in 6 months. So 6 months to 1 year is what timeline we have.
Now you said something about one of the exclusions is this overseas details of overseas trade agreements. So does this mean that we will again not be able to get the full details and disclosure on the Sampur coal power station?
Well, actually, I think on overseas trade agreements, and you'll have to forgive me because I can't refer to it very quickly.
Roman 5.
It's in 5. It's in section 5, but there is also something else dotted within here, which also mentions the fact that even when it's a trade agreement, within
commercial confidence. If you look at D, look at D, just after that Roman 5. Information including commercial confidence, trade secrets, intellectual property. Well, you can protect intellectual property. But now, once again, Asanka, I come to that question. Who decides whether this information, whether it's commercial confidence? Then there's another very funny thing. If it involves a fiduciary relationship. Now, fiduciary relationships happen every day in our lives. You go to a bank, the bank manager, and you are in a fiduciary relationship. I come here, you are in a semi-fiduciary, quasi-fiduciary, because you are supposed to know what happens here more than I do. Or say a client comes to me as a lawyer, I am in a fiduciary relationship because I hold some fiduciary trust that he expects me to have. So, who decides all this for us? And the problem is our public officers, like Asanka said.
Perhaps they'll have a chapter.
No, they have. You can appeal to the commission in 2 months.
Right.
And so I think I agree with you, Asanka. We need to look at the model. Maybe for the first 6 months we'll have some teething problems. I hope we can get our public officers, let's look at it positively, to look at right to information as a right and not as a right of the government to be protected. You see, that's where the distinction lies here for us. You need to impose upon our public officers, they are public officers, not servants of the government. Governments come and go, as I always say, the state continues, they serve the state. And it is a duty of the state to give the information.
Right.
It is not their job to protect the information.
But I mean, on this point, so an information officer shall seek the advice. So an information officer has to take the decision, but in taking the decision as to whether it's exempt or not, shall seek the advice of the commission with regard to an issue connected with the grant of access to any information which is exempted from being disclosed within 14 days.
So who will need information officers?
So all
public
public authorities will need information officers. So
there you go. That's another employment opportunity.
So I mean,
It's already an employee in there who will be nominated as the information officer, and until they are appointed, the CEO or the head of the department becomes the information officer.
I see. But back to Sampur, even under India's right to information act or bill, there are people who are unable to get details on the Sampur matter, and so we're blocked from both sides. But nevertheless,
but unless it can be shown that the public interest outweighs the
But I would have thought that public interest is omnipresent. It's always there.
But
everything, the public interest is always present.
But if it can be shown, or if to outweigh the harm that the disclosure
it'll be a tall order.
But these are the
sorry, may I just on the public interest aspect that can I just categorize this very simply? All of this is good.
Right.
That public interest can be showed, it outweighs the common interest, it outweighs the negativity of not giving the information, you must give it. Now, my question is, it is still, until we train officers, it is still this public officer who have been seated in the government department for the last 25 years, who's going to make this decision whether the public interest of my giving information to Faraz who comes into my office outweighs the duty to my master and servant and master sir not to give this information.
Right.
Immediately his mentality is going to be no. If I give this, this is going to be a problem for me. I'm not going to get my transfer, I'm not going to get my promotion and not my car. Alright?
This is a jolly interesting show this morning. Unfortunately, my producer wants to go for a break. So don't go away, we'll be back. This is, after all, Newsline.
Newsfirst Newsline with Faraz Shaukutali.
Welcome back to Newsline, and we have two gentlemen here who are discussing the newly passed Right to Information Bill. Sorry, there's a question here, Krishmal, I'll give it to you. Can the subsequent law take supremacy over the Constitution? This comes from a regular and dedicated viewer. Thank you. Thank you for watching, and thank you for the question. Can it?
Very clearly no. Constitution is supreme. We are run by a constitutional government. We have three institutions of government which are separated by the Constitution, and it is our Constitution that is paramount and supreme. So no law passed under the Constitution by any of those arms of government, which the legislature, can override the Constitution. Yes, but you must remember the wording in 14A is that the citizen gets access to right to, I'm talking the Constitution, not the Right to Information Act. The Constitution says it is in terms of the law that you get the right to information. So they have contemplated that they will pass a law. I have the strangest feeling for us, we're going to end up in the Supreme Court one of these days to determine, okay, I have the right to information under the Constitution 14A1, the new 14A that we amended. Then you bring an act and say you are restricting these rights. Constitution also has restrictions, as I said, which override the other, and I have a feeling that this matter will end up in the Supreme Court for determination. Because the Constitution cannot be overridden by subsequent law.
Thank you for that clarification. Now, the Supreme Court, how many judges is there?
13 is the card, I believe. I stand to be corrected. I've never checked actually the number, although I go there.
But it sounds to me that with all these things being churned out of Parliament, that the Supreme Court, are they going to be able to cope with this?
I'm very sorry to say that as it is having a lot of problems in getting out of our workload.
And especially I've noticed sometimes that you people from your profession wheel in various bundles of documentation, which I have some sympathy.
That's the matter I've been writing to the press about at length also for us. We need to find a system of handling laws delays, particularly when it comes to the highest court of the land. When constitutional jurisdiction is also vested in it, we have to find a way of either dissecting it, maybe having a separate court for constitutional matters. We have to address this issue.
And what about filing documents electronically in advance?
Well, we started it some time back. Unfortunately, it's not quite picked up as we thought it will, because we still have the computers picked up in the courtrooms.
Is that because most of your
maybe because we are not computer savvy?
Yes, you're averse to change.
I don't think that's a problem, but I mean, people say in my generation or after, probably who have studied abroad and all that, we are used to it. We worked in courtrooms with computers.
Is it a bit like learning to play golf? When did you take up to it? Right. Anyway, so a good move.
Yeah,
encouraging.
It's encouraging. I think if let's say someone asked how does an ordinary citizen make use of this act?
Yes.
I mean,
give us an example.
Yeah. So by way of example, let's say there's a government school,
yes,
and you have, shall we say, a legitimate expectation that your child could get into that government school, and
yeah,
your child does not get into that school.
Right.
You can file a request, yeah, to find out why your child didn't get into that school. But now that's how I would try to sell it.
Right.
But actually,
yeah,
it will be more difficult than that.
Right.
Because this is about requesting information.
Right.
So then to find out there may not be information that says why does your child not get into this school. You may have to request 4 different pieces of information.
Yes, you'll have to find out what the
catchment area is and the cutoff marks and things like that.
Yeah.
So there may be a few different questions, and then you have to tie in the different answers you get to answer your bigger question, why didn't your child get into the school? So really organizations like Transparency International Sri Lanka, I mean, in addition to our Colombo office, we have one in Vaunia and in Mathura. We have to really be able to aid citizens in requesting information and tying things together.
That response has prompted another question. Are we likely to see lawyers, with their little boards outside that says Attorney at Law, Justice of the Peace, Commission of Courts? Do you think we may see right to information specialists?
Well, under Sri Lankan law, unfortunately, although the British whom we took it from have now changed their laws.
Very well, and we've been left behind.
We cannot still advertise our services. So other than that blackboard, which is also regulated, the size and the white lettering or the white board on a black lettering, lawyers are supposed to not know any other colors other than the black and white, and we can only put up that board saying Attorney at Law and our qualification. Now, as you know, in England, you walk down Pall Mall or even if you go down Chancery Lane or you turn into Temple, maybe not in the barristers' chambers, but if you go a bit out on the outskirts and suburbs, you see, almost kill and come to me, I will set you free advertisement. We do immigration, have you fallen, have you broken your neck?
All you have to do is go up Tooting Broadway, and you can see boards that says immigration specialists, student visas, PR.
So we haven't changed our laws.
Right.
So until we change our laws on advertising temperature,
so you won't be able to hang up a board.
But can I just tell you something that's important to you as a media?
Yeah.
If you look at section 29, I don't know whether it's couched in there and hidden, but 29 has a very funny thing about third-party information. So now, say you ask us a lot of questions when you come on your shows for us, and your colleagues also ask us saying, so and so told us this, so someone supplied this information.
Yes.
Now, there is something about information supplied by third parties also in this, which I think is important to the media. You see, where a request has been made for some information, the way I read this, tell me if I'm wrong. The request has been made for some information, and the department doesn't give the information.
Right.
But then a third party discloses the information anyway.
A whistleblower.
A whistleblower, say.
Right.
Now that the person whom that information is affected by has a right to ask that department who gave this, how do you get the information?
Oh, really?
And then notice is issued under this section to that person who supplied the information or said to have supplied the information.
But we don't disclose our sources.
That is why I think this should be a good section for the media to have a look at, to see how, because I think as Asanka said, all of this act is meant for citizens, the citizens who can access information, not technically keeping the media in mind, but I think media should use it. This is a positive move. The media are also citizens. They must use their right as citizens. But this section is something with regard to third-party disclosures, something that you need to carefully study.
I see.
But the one thing that I would say though on the media point is that the initial draft bill of the initial RTI bill actually said something to the effect of any information which is provided through the RTI Act should not be considered to be something that can be disseminated. And so this was one of the massive drawbacks of that initial bill. It's a little bit like what I've spoken to you about in the past, Faraz, regarding asset declarations.
Indeed.
I mean, I've requested asset declarations, but if I show, even though you have the right and I have the right, if I show you 2,000 rupee fine and or 2 years in prison for me. Now, similarly, there was something that curtailed that before, but that has now been changed in this final act. So whatever is requested can be disseminated. So that's something which has actually very positively enabled media dissemination of information.
Let's see. This question has come in and from another viewer.
Questions coming in.
Indeed. All the widows and everybody else are up and about, and they are watching and doing the right thing by asking us, sending us questions. It says here, why can't, this is directed to you, why can't all these assemblies stroke forums get together? After all, their main objective is to put the Yahapalania on the correct path. Answer. Well,
the assembly is always open. I'm sure you have insinuations, and I can probably figure out where the question came from also. The assemblies and forums are all, I know about other forums. The People's Intellectual Assembly, Sinhalese Janata Buddhi Mandapaya, is a Mandapaya. It's open for anyone with the right vision of getting this country on track to come on board. 070-2246-895, 070-2246-895 is the number to call. Come on board.
Yes, do that. These numbers, I hope he got it right. Now tell me, this really is, it's a good move, isn't it? We must knock it all the time. Is it a good move, this right to information concept?
The concept is good.
Right.
The final act is a good. I mean, there are certain RTI bills that you will see. I mean, the initial draft bill.
Yeah.
You'd have been better off not having anything than having that. But I mean, we should be glad of this. But there are still a few gaps. There are some areas which have been fixed, though. So, for instance, let's say on the need to e-publish.
Right.
I mean, the initial draft mentioned that things must be available in the public authority's office and wherever possible electronically. That has now been made mandatory. So the mays have become shells on things like that.
Right.
Let's say even on something like disappeared persons. Some of the feedback that we had received was that if the family of a disappeared person wanted to find out information on their behalf, they can't use the act. And it was true. I mean, it wasn't sinister, but actually within
there's another question from another viewer who says, who decides if this information is released? Is it the...
That's a question that I was trying to tell the viewer too. See, there's the information officer.
Yeah.
Now, he is already someone in the department who under this act will be named the information officer for the department. Let's say public works department. I know there's a department. So he decides whether it's confidential, whether it's in Sri Lanka's economic interest, whether it's the breach of fiduciary relationship, all of this extra he decides. And if you're not happy with that, then there's something called a named officer, designated officer, to whom you can carry an appeal. But don't forget that these are all both two pieces in the same pot. So you go to the designated officer in the same department, who probably may be having lunch and tea together, and then that officer also, if he abides by his colleague's decision, no, we can't give this information, then you have to wait for 2 months for the appellate process to take place. You go to the commission, go by way of appeal, and then if the commission, hopefully the commission will decide in your favor. If they don't, go to the court of appeal. So it's a long process. I think we need to fine tune this and say, well, let's start with it, because as we all agree, it's a good start. We start with it. But as Yahapalane, we need to fine tune it and get it on track where we want it to go. So we need to fine tune this to be more simplistic and get these exceptions out.
I have another viewer who's telephoned in. The question is posed to you, Mr. Base Secretary. Has it been done in a haphazard manner?
I don't think so, in the sense that actually the final act, many of these exemptions, I mean, you can look across so many different RTI acts in the world. Our exemptions do not fall a great deal outside. I mean,
We're
running out of time.
No, I mean, it is in conformity with many of international best practices. However, it's really about the spirit in which public officers approach this.
Right.
And that is where the concern is.
Right.
The Establishment Code, last revisited 31 years ago, I mean, sits squarely against the sort of spirit that this RTI Act...
The spirit is one of encouragement. Shall we conclude that way?
Yep.
Do we have an official Secrets Act? Another question coming in.
We have an official Secrets Act. We have State Secrets Act.
Right. Wonderful. Gentlemen, thank you for being on Newsline. We appreciate your commitment and for not going to down south. Thank you very much. Thank you for having watched Newsline. It's been great having you. We're here every day, Monday to Friday, from 7 to 7:30, live, only on TV1. Take care, have a great day, and God bless.
Newsfirst Newsline with Faraz Shaukat Ali.